Good afternoon, and thank you for joining us today. I would like to welcome you to part 3 of FortneyScott's Workplace Legal Compliance webinar series entitled The Latest on Challenges to Illegal DEI. This webinar will be recorded. Today's presenters are FortneyScott attorneys David Fortney, Nita Beecher, Elizabeth Bradley, and Leslie Silverman. I will now turn the program over to Nita to start the webinar.
Hi, everyone. Really happy to be here today along with my colleagues, Leslie, David, and Liz. Hi, everyone. How you doing?
Great. Super. Yeah, good to see you.
Well, it's nice to see you. So let's get this started. I think illegal DE&I we've been talking about since January, and there's more stuff going on. But before we get started, let's go to the next slide and remind everybody that we are FortneyScott. And we are a Washington, D.C. law firm, and we are here to help you with any of your federal or state issues around employment law. And we also, David just dropped a podcast or is about to drop a podcast of Andrea Lucas. So we'll talk a little bit about that as we go on. But let's move on to the next slide, and we're going to talk about the agenda. We've talked about DE&I, but there are a lot of updates that we just want to bring everybody up to speed on. Starting with the status on DE&I, get everybody up to speed on that. And what guidance have we gotten from EEOC and DOJ? And finally, and most importantly, we're all going to talk about what employers should be doing to minimize the legal risks. And so to kick this off, Liz, would you kick it off on the status of DE&I?
Absolutely. Welcome, everybody. So to start with, we've talked about this concept before, but the whole of government approach. And what it starts with is first, it comes out as executive orders from the White House. Then there's unified agency action, followed by targeted attacks. And DE&I is sort of a great example of how the administration is doing this on topics. They've done it for other topics as well, but I think DE&I provides us a great example of that, and it's what we're here to talk about. So moving into
it's kind of a case study, because I think the Trump administration, particularly that middle box on unified agency actions, every administration says we're coordinating, we're doing this and that. The Trump administration has done an excellent job of silo busting. I mean, the agencies really are, and including the EEOC has said that it's no longer quasi-independent. It is just part of the executive branch. And there is a high level of discussion, coordination, we're going to talk about that a little bit, exchange of data and information that is occurring. So this isn't just talk when they talk about a unified executive and agency. It's the real deal.
It's like you've never seen before.
It is unprecedented, because before, different administrations, I think, would talk about that.
Yeah.
You know, everyone had their little silos, and after about a week, they'd go back and be in their silos.
It'd be like 20% versus 100% now.
Right. That's very different.
And the next slide sort of illustrates that for us. So you'll see within the DE&I concept, first, there are 4 key executive orders, most of which you have all heard a lot about, starting with 14151, which removed DE&I from government. Then that was expanded in 14168, was a policy of recognizing only 2 sexes. Then we had 14173, the big one that talks about the revocation of 14246, affirmative action for federal contractors. This is where the certification obligations that we're going to talk about comes in. And this is where the concept of egregious DE&I, unlawful DE&I. So this is sort of the key executive order that led a lot of the focus on what they're alleging to be unlawful DE&I comes into place. And then following that, there was the executive order, and I think this might have been the new one since the last time we met to talk about DE&I, was terminating enforcement of disparate impact claims. So that's what the executive orders are happening. Then we're going to moving into how did the agencies sort of unify and come to address this? It started with GSA. They're not going to enforce DE&I provisions in contracts. Shortly after that, there was the Secretary of Labor that said, even though 11246 regulations are still on the books, they weren't going to continue any investigations or enforcement agencies under that. We had an initial AG memo, which we'll talk about an AG memo in a moment. The Department of Education came out with FAQ. So you're seeing that EEOC came out. So this is that all of the different agencies that have some hand in the enforcement or touch on DE&I have spoken up and unified against these actions in alignment under the executive orders. The most important agency action, in my opinion, so far is the AG memo in July 29th. And I know we've talked about this before, but I think it's really important that we go back and everybody revisit it, look at it very closely, because I think it's the only clear guidance that we're likely going to get out of this administration on exactly what they're going to be deemed as illegal DE&I. And of course, there's things that we predict. If you have preferences based on race or gender, obviously that's going to be deemed unlawful. I think we all should spend a little bit of time really focusing in on the proxy concept. That is being, I think, interpreted pretty broadly. The concept of, even if you ask your applicants to explain how they've overcome difficulties in their background, they're deeming that could be a way to get to what else is happening, their national origin or racial diversity. So I think we all need to be very mindful, to be pay close attention to what comes out of the AG's office on that memo.
Yeah, that memo, I agree with you. I mean, that is, first of all, I think it's intentional that there's not a very precise answer
Absolutely.
on what is illegal DEI. So Attorney General Bondi's July 29 memo is clearly it. I mean, as recently as within the last week, a Justice Department lawyer in some of the judicial challenges has been asked point blank by the court during oral argument, what is illegal DEI? Can you define it? In a series of examples. The Justice Department before the court said, I can't answer that. And so I think that's indicative. I also just point out it's on page 9 of the memo, the discussion of proxy discrimination, because I want to connect a couple of dots. The Disparate Impact Executive Order 14281. Many say, well, okay, you said you discontinued disparate impact enforcement. However, the proxy discrimination kind of looks and feels like disparate impact. To be determined, but there is a bit of a tension in that, because I think the administration has realized in the intervening 4, 5, 6 months between when the president eliminated impact that they still, in fact, need proxy or impact type claims.
Let me add here that the EEOC guidance on this, I think it was in combination with DOJ, and those occurred in March. So it was before the July guidance. But we're going to continue to see this whole of government approach. I think in reading the tea leaves that we're going to see a whole of government approach to national origin coming up. And I think it'll be a joint guidance again.
Okay.
Yeah, there you go.
Great.
So then after this kind of along with the agency action, the targeted attacks have began. So FCC initiated investigation. EEOC acting chair sent, she was acting chair then, chair now, sent letters to 20 law firms requesting information about their DE&I practices. There was a charge, the EEOC did a charge against law firms for their legal internship programs, these attacks. Next, and notably, the Department of Justice has started civil investigation and sending out demand letters. Those started in approximately August timeframe. So this is starting. We know a lot of enforcement activity is, not all of it's public. We're hearing about it. We expect that it's going to continue. And I think this is probably a good time to pitch it over to David to talk a little bit more about the Department of Justice actions and what's going on here.
Sure, I'm happy to, Liz. And what I think is important as employers now, after 11 months or so, have begun to realize the federal contractors may have thought their primary EEO compliance monitoring and enforcement was the Labor Department. Well, that's clearly not the case. The EEOC was always either number 1 or number 2. It's clearly among those, but also the Justice Department has a very larger expanded role for most employers. And that used to be limited primarily to public sector and to higher ed. But the Deputy Attorney General, Todd Blanche, did issue the memo launching what's called the Civil Rights Fraud Initiative. This is a significant effort because it really begins to, some have described it as weaponizing, I'll use a more neutral term, applying the False Claims Act. And the False Claims Act, which is a long-standing statute, that is a statute that was actually enacted all the way back during the Civil War. And the thought there was that the government, frankly, was getting ripped off, that people were selling the government guns and munitions that were faulty, didn't work, and that the government couldn't really monitor what was going on. So if the problem arose, the government could be alerted so it wouldn't make, improper contract payments. It since has evolved. Its modern application has been directed more towards criminal activity, deliberate deceit, and misbilling associated with Medicaid, some Social Security, a lot of, if you will, pill mill doctor efforts that have been stood up. It is the first time that the concept of potential criminal and certainly very significant civil actions under the False Claims Act can be applied to civil rights compliance. That is a completely new concept, untried, unprecedented. And indeed, the Deputy Attorney General does talk about aggressively pursuing civil rights related claims and specifically calls out, and of course time rolled through and we did see that colleges and universities were the primary initial recipients. And clearly, Liz, as you mentioned, the law firms and the universities, those are the two sectors that have been the primary focus of the administration. And so far, I don't think it's the sole focus, and none of these initiatives are limited to those sectors. But I think there are, because for our higher ed friends, you're not out of the woods yet. For those that may not be either in law firms or higher ed, I think it's a precursor to what we're going to be seeing. And so let's talk a little bit about how the False Claims Act works. And we're not going to give a full tutorial on that, but let's just jump into the next slide briefly. So with a False Claims Act is initiated either by the federal government or by individual whistleblowers. They're called relators. And when a False Claims Act, and it's important because most of you today are familiar with the EEO resolution, where you file a charge, there's an investigation by a government agency, opportunity to conciliate, and then there may or may not be litigation filed either by the individual or the agency. And, it's variations, but that's sort of the template that most of us are familiar with. That is not what happens with FCA litigation. The litigation can be initiated either by an individual whistleblower called a relator or by the Justice Department. The Justice Department, when it starts an investigation, it looks at other information, maybe through tips supplied, and then it will issue civil investigative demands, CIDs as they're called. Those demands we know were issued to not hundreds, but handfuls, and we don't have complete transparency into this because it's not publicized. But we know certainly there are multiple employers that have received these CIDs beginning in or about August of this year. So far, at least publicly, there have been no actual False Claims Act filings that occur. And we sort of caveat that because when an individual files a false claims, they don't have to tip off the employer. They can go directly to court. The claim is then put under seal. There's an opportunity to resolve it at that point with it under seal. The Justice Department is notified. It has the option of joining and participating in the proceeding. So those under seal processes can extend for months, or in some cases years, in other types of False Claims Act litigation. But I will say that in terms of how this was designed to create kind of I call it the sonic boom. They put these DEI standards out, and now they want people, and in our experience, it has caught the attention of the boardroom, the general counsel. This goes right to the top of the house.
So, and I know they're not public, but what have you heard about the substance of the CID demand letters within the DE&I concept? What are we seeing in there?
Right. So they vary a little bit, but the other thing that has occurred, and it's evident when you see some of these CIDs, a lot of the experienced attorneys in the Justice Department have been removed, either voluntarily or involuntarily, but they're no longer there. So the demands are not very well crafted. They don't track traditional EEO concepts. They're very broad based. Many of them go back to 2020. Many of them are just dump all workforce information and provide it to us. And it's very hard to avoid these demands. I mean, there is some room for negotiation. And I should mention that in addition to Main Justice, that is here in Washington, that has nationwide enforcement, all the U.S. attorneys have been directed as one of their top priorities to investigate and find False Claims Act litigation to file relating to illegal DEI. So it's about as big a dragnet as the federal government can launch to rake over any employer with federal contracts or any grant recipient. Those are the two targets.
Mm-hmm. I would just pause and on this point is I have heard that some of the requests are give us your prior affirmative action plans, give us some of that data. Just a pause point. If anybody gets one of these, immediately contact your internal counsel. I don't know who it's coming to, but some of them may look like, oh, well, the government already has some of this data. What is the harm in providing it? But I would take a pause and make sure your internal counsel is looped into this because they're
1,000%, and make sure. Yes, because they've been sent to all sorts of weird recipients, right? And so we'll leave it at that. That's good. All right, but anyhow, so hopefully no one has direct experience with that. This weirdness of asking for affirmative action. I do want to pick up on that.
Yeah,
there are some in this administration, we know from the discussions we've had with them, that think that compliance with Executive Order 11246 may constitute illegal DEI. I think as a matter of law, that is wrong. I think that's a flawed premise, but nonetheless, again, going back to that lack of expertise that's occurred, that is how some of these appear to be teed up. So buckle up. It's very challenging.
So as you say that, I was thinking, well, the employers have a hook here because they are getting grant money or they're federal contractors. So even if they wanted to challenge the jurisdiction or in a declaratory judgment or go into court, they'd be less likely to do that because some of these are Title VII principles, and DOJ doesn't have a role under Title VII for private employers in that way. So
well, we do at this point have Leslie experience with higher ed having to negotiate on these very topics.
Right.
Well, and the other thing, most contracts and grants and a wide range, and certainly the Labor Department has begun to aggressively look into this. Anyone who's a recipient of federal money, whatever the delivery vehicle, when you look at all that little fine print that you tend not to read, it almost always contains, and you agree not to discriminate. It doesn't reference Title VII. It's just a kind of a throwaway line, like, and who isn't going to agree to that?
Yep.
That's become the linchpin in a lot of these discussions. All right.
So Leslie, you want to kick off the next slide?
Sure.
And guys, we have a lot to cover.
Okay.
So let's keep it moving.
Too chatty. Sorry, Nate.
Be quick. So, I mean, this is an example of an industry, and I think higher education, having just finished paying for a lot of it, is an industry, and where the Trump administration has applied that whole of government approach and the executive orders and all the different DEI issues in a smorgasbord of ways to, several prominent universities. The first settlement with Columbia was the biggest by far, and the only one that also included a settlement with EEOC. So of the $221 million, it was $21 million to EEOC. EEOC had a separate commissioner's charge that now Chair Andrea Lucas had filed against Columbia during the Biden administration and had investigated. And so that that settlement, that part of the settlement is to do a settlement fund that will just go to employees of Columbia, which could include students that work for the school, for anti-Semitism. But there are a bunch of different issues in each of these settlements. As you can see, the most recent settlements between UPenn and UVA and the administration are for no money, but they are for certifying and reporting. And there are two of these, the one against Brown, the settlement with Brown, the settlement with Columbia, where there's a bunch of education reporting, and it's reminiscent of other things we're seeing, isn't it, Liz?
Yes. Yeah, I mean, I think one of the key takeaways here is the requirement that certain of the institutions provide admission data to the government.
Right.
And what this is part of is there's also proposed modifications to the iPads. And a little shameless plug here, tune in December 2nd. We're going to have an entire webinar detailing the proposed changes to the iPads. One of the biggest foundational issues here is the administration believes higher ed is still discriminating, and they're putting in more robust data reporting tools through the iPad in order to collect admissions data. So they want to see whether higher ed is still discriminating in their admission processes. And they realize that because they didn't have the data to know otherwise. And I think that goes into maybe a little bit what they're seeing in the DE&I world. Are they going to need to continue to have data beyond higher ed? Because remember, higher ed's a bit of the proving ground for what they do in other areas. Are they going to get back to collecting data from other employers, realizing now they need the data?
Right.
One important thing, I think, Leslie, just to follow up on what you said, is a couple of the more recent settlements, and I believe it was certainly Cornell and UVA, there's a certification requirement that will have to be done under penalty of perjury. So here we go with the fraud, penalty of perjury and so forth. And so let's jump to the next slide. Let's go back to the certification requirement for our favorite executive order 14173, because it's very unusual in that, one, it's requiring federal contractors and those who are federal grantees to certify that its compliance is in all respects to all applicable U.S. federal anti-discrimination laws. And they're saying that it's material. David was talking about that's part of the False Claims Act requirement, that it be material to the government's payment decisions, and also that it does not operate any programs, in this case, promoting diversity, equality, and inclusion that violate federal antitrust, the anti-discrimination laws. So again, this is what that provision is.
One piece I want to highlight here, is read this closely. And I know there's a lot of uncertainty about what is unlawful DE&I and how the administration is going to enforce that. But I've also heard people refer to this as the certification saying, I have no DE&I. And that's not what this is. And I think we all need to be very mindful of that. It's that you do not have DE&I programs that violate any U.S. federal anti-discrimination laws. You can still have DE&I. How you do it is important. Potentially what you call it can be important, but misstating this as no DE&I is not accurate. And so we just need to be framing this inappropriately.
And is this a once a year certification?
No, this is a certification that likely is going to be attached to every contract or grant or contract like document that you execute.
Purchase order,
purchase orders. This is going to be often, we've seen it in the general terms, and we've seen it come in as an email, but it is contract specific. So if you have multiple contracts, you're executing this multiple times.
Okay, because like the UVA one, the president has to do it quarterly. So I was just curious how often.
Yeah.
A couple of things. Also note that it's limited to U.S. Law. So various states, of course, do have directly, have requirements of affirmative action if you have state programs, et cetera. So there is some tension because certain states have laws that appear to be potentially, I add, in conflict with some of the way the federal laws are being currently interpreted. They shouldn't be in conflict, but at least the interpretations raise that possibility. That's been another common source of inquiry. The final thing I'd add, this certification that we've reproduced here is one that we saw frequently. This certification, however, has not yet been codified as part of the federal acquisition regulations. There's in fact a pending proposal, but so even the authority to have this certification, which is simply based on an executive order with no underlying regulatory implementation, is a bit of a jump ball. As a practical matter, most people are rolling over and certifying, but.
Well, and let's go to the next slide because that explains exactly what's going on. These are all places where we have litigation around this very executive order, along with 14168, which is usually they tend to be together because it's also having to do with the two sexes. We know there was a big one that came down in Maryland. Fourth Circuit lifted the nationwide preliminary injunction blocking enforcement of 14173. They just had oral argument less than a month ago in front of the Fourth Circuit on the preliminary injunction. We also have one in Chicago. It's only focused on Department of Labor grants, but that one has a preliminary injunction blocking the Labor Department. Another one that's really big is one that just came down at the end of October, where they granted another preliminary injunction. So we're looking Fourth Circuit, Seventh Circuit, now we're in the Ninth Circuit. They had a preliminary injunction barring the enforcement of both 14168 and 14173. And it was, although it was applicable only to Seattle, she had issued one previously for a bunch of other cities and states and counties. So there's a lot of litigation. But with that said, it's not just litigation against the government, Leslie.
No, it's not. Next slide. So we are going to pick on one company here with this slide, but it is really a conundrum for many employers that they're going to be facing. And let me preface this with I came from the EEOC at one point, and I can tell you that when employees get fired, they're more likely to file charges. So, when we see dips in the economy, we see increases in charges, increases in lawsuits. And so employees might gripe about going to a training or this or that, but it's when they're fired. So what happened here? This is a situation. We had a 26-year female IBM executive who had based on her complaint, a really solid record at the company. And a new boss's boss said, some disparaging things about her, and some, at least according to her complaint, some interesting actions. They moved her place of business from Maryland to Massachusetts. She went, and then they let her go. And she was, there were 5 African-American executives out of the 7 in her division. All were let go. And so as part of a RIF, and not surprisingly, she is suing her employer. That suit came out at the end of October for over $1 million. Well, just this past July, IBM settled one of the claims that it had from a white male executive who had been fired by IBM, who had claimed that he had been squeezed out based on their DEI program. So employers are betwixt and between, and I think we're going to see more of these from both sides.
So guys, let's talk really briefly, because we've covered a lot of, let's go to the next slide. We've covered a lot of the DE&I guidance already, but let's just touch on it briefly. Leslie, we're going to start with you, if you don't mind, because it kicked off with EEOC and DOJ.
Yes, EEOC and DOJ issued several guidances back in March. I had mentioned one was geared towards employees, one was geared towards employers. And it was to sort of introduce these concepts and to talk about how use of especially race and sex in employment decisions and other employment actions can violate the law, and that can be an example of illegal DEI. And that includes that sort of concept of balancing your workforce, so workforce decisions that are based on someone's race, someone's gender. Also talked a lot about DEI training, creating a hostile work environment, and it gave examples of concepts for the first time that could potentially create a hostile environment, use of words white privilege and other words and other examples. And there's always been this concept in the law where when you segregate employees based on race or sex or other protected characteristics, that can violate the law. So it also, this talked about ERGs and what they could and couldn't do a little bit, not completely. It didn't give all answers to questions, but it started the ball rolling. And, you know, from what we're hearing from Andrea, Lucas, I don't think we're going to get any further guidance from EEOC directly on this.
But David, let's turn to the next slide and talk about, you were talking about this AG memo. So let's talk a little bit, because it did give some clarification that I think employers need to keep in mind.
Right. So these have sort of, they've sort of chunked out the guidance. It hasn't just been articulated through comprehensive regulation or in the more, so it's somewhat of a non-traditional way, but building on the joint guidance that Leslie just described at the end of July, the Attorney General issues a memo, and it's nominally addressed to the government agencies. I think it's really pretty fairly also addressed to the contractor and grant recipients community at large. It's a public document. We've got a link for it there, but anyone that's receiving federal funding, and it spends 10 pages plus going into a pretty detailed discussion as to what may constitute illegal DEI. I think that is a must read for anyone that's helping their company on compliance, anyone that's advising companies on compliance, because as best we can tell, this represents the, if you want one-stop shopping, this is the single most comprehensive articulation of what the administration means by illegal DEI. And it talks about preferential treatment. And really, when you read it, most of it isn't stunningly off track from traditional Title VII concepts. And, you know, with proxy segregation based on protected characteristics, that is unlawful under Title VII. Trainings, now they focus in and they really now start reaching into some of the traditional, I'll call them more aggressive DEI programs that had been deployed. Trainings with stereotypes, you know, and the administration often cites, well, there were these programs where whites had to stand up and apologize for what may have occurred historically, things like that. And I don't know how common those were personally, but nonetheless, there were at least some instances where programs like that were run, and the administration, I think, has used that to illustrate the stereotype point. So really focusing anything, whether it's setting aside opportunities, diverse slates would be viewed, Rooney Rule, a number of things that go into that. You know, the AG's memo makes pretty clear this administration is going to view those as being legally out of bounds. So you're forewarned.
And not everything, you know, not everything in that memo necessarily would we as lawyers agree with, but we need to know what their position is in order to advise clients where the risk should be, which we'll talk about a little bit later. It is what you all talked about already. The proxy discrimination part, I think, was not surprising, but the focus on it, I thought, and I agree, I think it's shall we say, disparate impact with a different label, maybe?
Proxy for disparate impact.
Yes, very good.
There you go.
Well,
yeah.
Whatever you want it to be, yeah.
Yeah. Well, and so Leslie, we have gotten some additional information from Andrea. So you and David just also did a podcast. So what have we heard from the chair?
So let me clarify what I said. We are not going to see probably written instructions from EEOC, but as I've said in every time I've talked about EEOC, certainly in the past administration and this administration, is Andrea Lucas does not hide the ball. She is out there. She is speaking. I commend all of you to listen to David's podcast with her. It's fantastic. I want to talk a little bit about some of the things she said there and other places that I've heard her speak. And one thing she tends to focus on is merit-based. We hear that word all the time, but just how equal treatment is so important from the start. And she'll go down to the studs with that to see, are you really judging people the same, their grades, what have you, depending on what the hiring, what the matter is. Second, so Andrea Lucas became acting chair in January. The president then terminated 2 of the sitting EEOC commissioners who were Democrats. So the EEOC then went without a quorum. It went under a delegation of authority. Then a 3rd commissioner was confirmed, but then the government was out. And now we have an EEOC with a quorum. I mean, there's 5 commissioner slots, but it really needs only 3 to zoom ahead. And so what are we going to see in the future? Well, there's some things, there were some suits, but we are really going to see more. We're going to see bigger. We're going to see systemic suits. We're going to see suits that are challenging issues that they couldn't challenge before because the circuit law was against it. And we're going to see new issues that perhaps they needed to vote for to go forward. So we will see that. They're poised to make big moves there. Also want to talk a little bit about data collection and analysis, because Chair Lucas has said at least several times that I've heard that her concerns about collecting demographic data are not in the collection in itself. It's more in how it is used and shared. And I want to focus on shared primarily here because she couldn't be clearer on this. She wants guardrails around the data. She believes that when the demographic data is shared beyond HR and legal, that it's problematic and that it can incentivize unlawful decision making. And she's even, suggested, well, that's an inference, a presumption that if you share that data, then it's going to be used for an illegal purpose. And lastly, I wanted to talk about the proxy discrimination aspect of it. Chair Lucas has said repeatedly that she's focused on employers' motive and their actions, less so than the label of DEI. She said, I wouldn't recommend using the label of DEI, but she said, just changing the label to something like belonging and keeping the same initiatives, policies, and practices are not going to get the job done. She said, we can look at what's on the web and what employers are doing. We hear about it. And she's really looking to see that employers are changing their practices. So she's, she definitely recommends taking a step back, reassessing practices, and to find a way to help employees individually and collectively based on, merit, things like that. So again, we're going to continue to watch and listen to hear what she has to say and what the commission, now that they have a full commission, that they can do things. So we'll see.
I think,
David, anything
Leslie,
else?
just one other thing to add. I think that recognizing we've just come off this 43 day shutdown. The EEOC and the Labor Department are all on a continuing resolution, as is the Justice Department. That resolution, so what that means in plain speak is they're funded until the end of January. At that time, if Congress has not reached some sort of agreement, they will run out of money once again. It is possible there could be another shutdown at that point. So we could have shutdown 2.0 at that stage. I think as a practical matter, Chair Lucas, now that she has the quorum, they are going to put the pedal to the metal and initiate and try to get as many things rolling as possible in a period that normally would be kind of sleepy over the holidays, the end of the year, what have you. And I think they're going to try to potentially initiate some of the rulemaking changes. I do think, for what it's worth, I believe that the EEO1 data collections will occur this spring. Many companies are worrying about, do I need to have resources for that? Yes, you should plan on doing that. Will it occur in the future? Wouldn't surprise me if that does get rescinded eventually, but that takes a while for that process because it's notice and comment. And the same would be true with a number of other changes at the EEOC. So they may initiate some of those changes, but it takes a matter of months, not days or weeks, to get those done. Filing litigation, that could occur in the next, between now and the end of January. I think they have a number of things lined up and they'd like to kind of make an impact. And I think Chair Lucas is she's been quite impactful without a quorum. And I think she's very interested in showing with a quorum, here's what I can do.
And a new acting general
counsel, that's right.
Has a lot of litigation experience, so.
Speaking of the new acting general counsel, quickly before we want to turn to practical advice, what do we have to say about that, Liz?
Yeah, so at the SHRM Blueprint Conference, we'll move on to the next slide, former OFCCP Director Catherine Eschbach came and spoke, and she started, and she's now in a role with the EEOC. She made it very clear at the top of her comments that she's speaking on her personal behalf, not in either her former or her current roles. It was sort of an interesting take on approaching the talking points, regardless of the reason why she was there at the time, whether it was her personal or professional beliefs. I think it's going to drive what we see and how she engages in her role. She led with the whole of government enforcement. She led with the talking about not only will you see this enforcement against illegal DE&I from traditional enforcement agencies, EEOC, now DOJ, she referenced potential blocks to merger approvals and other types of activity far beyond what your traditional enforcement. And we've seen that. We've seen that in the news. So she's acknowledging it. We've seen it. We know it's happening. Few other key things that, and David referenced that there are people in the administration who believe that your compliance with 11246 was likely engaging in unlawful behavior, or it was a screen to allow you to engage in unlawful conduct. Based on her comments, I believe that is the foundation from which she is coming. She referenced placement goals, whether they were previously for 11246 or going forward aspirationally, are probably unlawful behavior and is going to be a trigger for negative attention and enforcement activity from this administration. She referenced that she went back in her role with OFCCP and reviewed prior affirmative action plans that were submitted to the agency. And she went through and was very surprised by how many of those were very detailed submissions that interwove 11246 compliance with DE&I activity. I think it would also be pretty entertaining to see. She also referenced some of that were very bare-boned and she kind of praised the bare-boned ones. I'm wondering how many of those bare-boned ones were subject to very detailed RFIs from the agency prior administrations. So I think it's very important there. She did consistency here. She talked about data collection is still permissible, but she also said who has access to that data is very, very important. And she said that as long, it should be said in legal, and that decision makers should not have it. And she expressly called out not giving the data to DE&I professionals within the organization. Yes, Leslie.
Did she say anything about what she was going to do in her new role as EEOC acting general counsel?
She did not speak within that role at all. She focused her as information and her perspective coming out of her former role. And in her personal right now, she did not lead into her EEOC
Got
role.
it. Okay.
And the last thing I kind of want to piece in here is the discussion for what's going to happen with 503 or VEVRA. She focused that the EEOC is going to be, OFCCP is going to be focusing on 503 and VEVRA, that they're working on a self-audit program. What exactly that's going to look like, she didn't give us much feedback on that, but she did kind of say that needs to be the focus of where OFCCP goes forward. What the enforcement is look like, she then shared, kind of depends on what's going to serve the stakeholders best. So I think there's a little bit of wait and see there, what's going to happen with the 503 and VEVRA.
Right. Now, the self-audit program, and of course, Catherine Eschbach now is the general counsel. She may have been just a concerned taxpayer when she spoke at the blueprint, but she's now the acting chief legal officer of the EEOC. But the Labor Department, when she references the self-audit program, this summer, July 25th, they issued a rollout. Multiple agencies have self-audit programs. The general characteristic is that, and you can use the Labor Department almost as consultant for expertise, but the programs, you audit them, you tell the Labor Department we're auditing them. Some of them have various certifications or reps and warranties that you've done the certification. And what that means is, generally speaking, you are removed from the routine audit inspection list. And the agencies that have now included that, because they've really gone all over on this, the pension agency that Janet Dillon now leads, the mine safety agency, the OSHA agency, the office that oversees union compliance, Office of Labor Management Standards, the Vets Employment Agency has that, the Wage and Hour Division has a self-audit and compliance program in place, the PAID program, and others. So I think, building up on now acting general counsel Eschbach's point, it is highly likely that there will be a similar type of program for 503 and vets at a minimum.
Okay.
At a minimum. Yeah.
And then one final kind of mic drop moment she had, which also goes back to this concept, is there are people in this administration that believe that compliance with 11246 was in essence unlawful. We don't agree with that. Her mic drop moment was she did advise, if you are relying on attorneys and vendors who supported you in these efforts previously, you should reconsider where you're getting your advice and counsel from. So I think that's just, being mindful of that is the perspective that the administration is coming to us for.
Well, we want to spend the last 15 minutes or so here. Let's kick to the next slide, because really what we want to talk about is all of this going on. So what should employers be doing to minimize these legal risks? And with the next slide, David, you want to kick us off?
Sure, I'd be happy to, because this is really, okay, all of this, some certainty, some uncertainty, as a practical matter, what should my organization be doing? First and foremost, if you have not already, you should engage in a privileged audit of your DEI and affirmative action program. By privileged, I mean with at the direction of counsel, make sure it is completely privileged. You'll focus on the new all the new executive orders that are applicable, but particularly 14173, and of course, Title VII and EEO statutes. Be prepared to make necessary changes. Those will, all of us on this webinar have done many of these sorts of efforts to date. I will say we found some organizations that shortly after SFFA was decided by the Supreme Court, and not just higher ed, but employers did kind of, in many cases, it appeared to be more of a lighter touch audit. And I would just caution that if you did an audit at that point, I would double check and make sure under all the standards, particularly that July 29 memo and some of the other guidance, consistent with your organization's priorities, guiding principles, and the legal standards, you're where you want to be.
And I would just a little chime in there is before you start this, catalog everything what you have, but really come to it and say, we understand where the legal line is, what violates Title VII, the other anti-discrimination laws. Then there's that gray area of what does the administration not like, but is still lawful. And you need to start your assessment with a bit of a mindset of where you as an organization want to be. And that helps you guide, because it's an overwhelming thing to undertake these assessments. So you need to start with it with a clear direction.
Agreed.
Well, and looking at the next thing is, and I think, Liz, we can talk about this a little bit. You need to educate, let's go back a slide, please. You need to educate your HR and management on the new federal requirements. And you can't just dress up what you've been doing all this time, probably since George Floyd and before, by simply, and somehow think you're going to be able to hide that. And Liz, you were at that SHRM conference, and talk a little bit about what sense you got from people there.
Yeah, it was interesting. I was in a breakout cohort, and people were openly kind of talking freely. And I was a little surprised to hear people were disappointed or surprised by the content of the SHRM conference because they expected it to have more sessions on how to continue to do the DE&I that they're currently doing. And there were a lot of individuals in the room who were very surprised that DE&I, a lot of the programs are going away. So I think that is educating HR and understanding that we need to push this down through all the levels, that traditional DE&I, as a lot of companies were doing it and referring to it and acting on it, absolutely needs to be changed. And I don't think everybody's realizing that yet. I found that surprising.
And I think it's really important that one of the things you have to do is everybody needs to come to this understanding, starting at the top, as I think David kicked it off. It needs to start at the top and be very clear as you work your way down. Because honestly, many of these companies spent a lot of time and effort to get everybody on board with DE&I. And now they're saying, wait a minute, we just spent all this time and money for conferences and all this kind of stuff. And when you say, no, you can't do that, no, you can't do that, you can't send only blacks and females to these conferences and so forth and so on, then they really come to a new understanding of what's going on.
And I want to talk a little bit about just policies and trainings that aren't necessarily DEI focused, and we cannot forget about those because sometimes it's done by your training department or HR, and legal is an afterthought or not consulted at all. And a lot of these concepts and what's to come in the future are baked into lots of different aspects of policies and trainings, just Title VII training, for example. So it's really important to have counsel not be an afterthought, but actually really directing the training, engaged in, directing the process, engaging in the discussions, and for the purpose, the direction of counsel, for the purpose of giving legal advice, revisions coming back, comments. You want the attorney-client privilege to protect, to protect the advice. And ideally, I mean, many of our clients and other, it's very important to think about outside counsel. We see a lot more than inside counsel, and we're watching for all the development. So that's helpful. We are also helpful internally to say, look, this is what outside counsel is advising. And obviously, you can do more, to protect the privilege that way.
Can I just tell you that I was in corporations for 21 years. Outside counsel is often used to deliver messages inside counsel can't give.
I figure that out when I came back to private practice.
Well, to be the bad guy, and also it helps in terms of clarifying. Inside counsel can often also give business advice, which is not privileged, exactly. Whereas legal advice, of course, is. So yeah, I think the other thing, key takeaway in this policies and training, this is a much more robust, holistic assessment. This isn't a keyword search. This isn't just scraping your website and changing the nomenclature on the website. You need to really, and to be fair, this is what Chair Lucas has said. This is what Attorney General Bondi's memo says. And this is really what's baked into what the information on this slide. You have to, in a meaningful way, go through and look at written policies, practices, trainings that have occurred or are going to occur, outside organizations you're partnering with, websites, the shareholder statements. It's a lot. It's a lot, really is, if it's done correctly.
So let's jump. We're going to run out of time here, as we always do. Next slide, please. Liz, how about data?
Yeah, I'll take the first two. I'll lump these together. So data collection is still permissible, and I think you should still do it, right? How else are you going to know whether or not you have issues in your selection processes, et cetera, and your hiring? You need to be collecting applicant and employee data. Employee race and gender data is still required under EEO1. I think that's probably going to continue. It's the collection of applicant data that it's still permissible under federal law. Remember, it still may be required under your state affirmative action obligation. So don't undo any of your data collection obligations until you really make an assessment of, do you have any local or state obligations to be collecting that? And then two, really think about how are you going to use that data? You should be doing workforce analytics, but you need to be looking at those under a Title VII lens now and not a 11246 lens. If you're measuring your hiring based on your brick and mortar, remember 11246 thought everybody was hired at their single shop, and you're doing it by EEO category or OFCCP based job groups, I would recommend you reevaluate that. That's likely not how your decision making happens. Start fresh with that. Think through in today, in 2025, 2026. How do you make hiring decisions? How do you make promotion decisions? Wipe away the 11246 concepts, bring it back into a Title VII format, and do those analyses to see whether or not you have any disparities in your selections. Reevaluate whether you're going to do an overall utilization and availability. You do not want to be setting higher goals, so you need to be very careful about exactly what data analytics you do and how you're going to use the results. So working with counsel to make that decision before you do any analytics, know what you're going to do with the results.
Yeah, and can I just build out on that? Certainly, Chair Lucas has made it abundantly clear that to do what Liz has just outlined on a privilege basis with Human Resource Department and legal doing that, fine, at least facially fine. But what you do with the results and who gets the data, who gets the results. So as recently as 12 months ago, people would often do these assessments and then publish. You know, the engineering department were really a little short of women in some of our STEM jobs, so we're going to be focusing on that. Okay, that becomes a do not do. And Chair Lucas has made this abundantly clear. She said, in fact, her characterization is, I'm going to presume discrimination has occurred, except for those that need to know the data in order to conduct the analytics. She supports the analytics, she supports compliance, but so the posting of results, which was wildly popular, I think is off.
There's a perception. If you set a goal, you are going to take action to meet that goal. Any of the action targeted based on race or gender is unlawful, and that is the approach that they're coming to with it.
Correct.
I mean, that
And they-
all reminds me of what a difference a year makes in this whole discussion. I mean, every day we're seeing, you know, I mean, some of these are obviously building on one another, but we are seeing shifting administration priorities. We're seeing new laws, some in support of those priorities and some against those priorities. We're seeing active litigation challenges from both sides. And again, what was perfectly acceptable a year ago is now suddenly high risk. So that is why it is so important to periodically reassess your programs, your policies, and your practices.
Yeah, and on that, my experience has taught that often the people, and this kind of goes to, I think, acting counsel Eschbach's comment at Blueprint, because there can be backsliding when the organization says to the DEI team, you need to stop doing this, you need to stop doing that. Backsliding, meaning sometimes a local manager may not fully appreciate that, a local DEI person, whatever. The realities are we have seen backsliding. And so I think that's what, I think that's what the government officials are calling out. And I think, Leslie, to your point, this ongoing review and this internal collaboration to make sure that doesn't occur. I mean, in some organizations, we're talking about a big turning the page, and that's hard. People are people. Some organizations solved that problem. They just fired all the DEI people. But most did not do that. That's a pretty draconian response. That's not a terribly nuanced response. Most do want a nuanced response because they want compliance, but they don't want backsliding. And so that, you can't, it's not one and done. This requires ongoing, meaningful engagement with all the stakeholders and only informing them appropriately, not oversharing data, as I said before.
And paying attention to what's going on, even if you don't like it or you want to, put your head in the sand. You have to pay attention because it affects your business.
Right.
Well, we have run out of time. I know that's hard to believe, but Davey, you want to kick off the last slide?
Sure. So just and thanks, Nita, and all of you for a really, I think, very informative and very timely discussion. Because so many people are standing up their 2026 budgets, and they're trying to decide how they're going to approach these issues. And we have a number of ways to help you beyond this webinar. We have stood up a resource page, and I would encourage you to look at that. We do keep that updated. We do a bunch of podcasts, and we talk to people from the administration. We've mentioned that we have Chair Lucas coming on. That podcast has just dropped. Then we also do various webinars. We do client alerts, all that sort of thing. And all of you are part of that community. Some of the best ideas for the podcast have come from our friends and listeners and clients who say, what about X, or could you do this? So I would encourage you, we love getting that type of feedback. And we apparently have thousands of people that listen to those things, and it's very helpful. So help us help you in that regard. And certainly if you do have any follow-up questions as you embark on the ongoing monitoring of DEI issues for compliance, notice we're not saying eliminate. None of us
No.
have suggested
No.
that. I want to be clear. We are pro DEI, but we're also pro legal compliance. So with that in mind, we're here to help if we can. So thank you, Nita.
Thank you, guys.
Okay. We would like to thank you all for joining us today. If you have any further questions, please email us at info@FortneyScott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.